Your Honour, my name is Guy Kienage, and I appear for the defendant Johnny Wishbone in this matter. My client is facing 106 charges, and I am applying under Section 590AA of the Criminal Code to exclude some of the evidence against my client. If it pleases the court, I will tender my submissions now. Your Honour, I would like to raise the following issues. My client is an Indigenous person who is a juvenile and was not cautioned properly as a particular person by the police prior to being questioned as required by Section 431 of the Police Powers and Responsibilities Act. Further to this, the initial interview was not electronically recorded. Your Honour, it should have been evident to the arresting police officers that my client is a juvenile. Under Section 421 of the Police Powers and Responsibilities Act, if the police officer seeking to question someone reasonably suspects that the person is a child, the child must be allowed, where practicable, to speak to a support person of the child's choice. And the questioning must not start until the child has had an opportunity to speak to the support person in a setting where the conversation would not be overheard. My client is a child for the purpose of the definition provided by the Youth Justice Act, as he has not yet turned 17, and yet was not given the opportunity to speak to a support person before the police officers started driving him around in an unmarked police car, asking him questions such as, "Did you break into that house? What about that house over there?" To which my client answered, "Yes, sir," or "I'm not too sure, I don't remember." The police officers would have had reasonable time to make a telephone call and request a support person to communicate to my client, or could have merely delayed the interview until my client has had an opportunity to do so. Although my client was provided with a support person at the interview that took place in the police station, this support person was not chosen by my client. Further to this, my client was not allowed sufficient time with the support person. She merely instructed my client to answer the questions the police asked. The police should have delayed the recorded interview until my client had time to speak to a support person chosen by him privately. I would now like to draw your Honour's attention to Section 418 of the Police Powers and Responsibilities Act. This provides that before the police officer starts questioning a relevant person, they must inform the person that they may speak to a friend or a relative to inform them of their whereabouts and request the person be present during questioning. My client was never given this opportunity to make a call to his friends, family, or a lawyer. This resulted in my client, a juvenile, being driven around in an unmarked police car for a considerable length of time and then being taken to a police station 10 to 15 kilometers away from his home without him having the opportunity to make his mother, father, or another relative aware of his whereabouts. The police did not contact a parent or a guardian at any time during the proceedings. Section 420 of the Police Powers and Responsibilities Act provide that if a police officer reasonably suspects that the interviewee may be of Aboriginal or Torres Strait Islander origin, they must contact legal aid. Unless the police officer has reason to believe the interviewee is subject to no disadvantage in comparison to other Australians. Pursuant to Regulation 25 of the Police Powers and Responsibilities Code, the police officers should have posed questions to determine whether my client understood the questions being posed to him. It should have been evident to the police officers at the time of the arrest that my client is of Indigenous origin. As my client is a juvenile and has no other significant advantage, it is reasonable to assume that he would have been at disadvantage in comparison to other Australians. The officers failed to question my client appropriately and made no attempt to contact legal aid, despite them having ample time and opportunity to do so. Next, Your Honour, I would like to draw your attention to Section 436 of the Police Powers and Responsibilities Act. Police officers should electronically record the questioning of relevant persons wherever practicable. In the case of my client, the police failed to electronically record the questioning that took place in the police car during the initial stage of the interview. As there were 2 officers in the car, I assert that it would have been possible for one of the officers to record the interview. There was no proper written record of the confessions that were produced to my client pursuant to Section 437 either. Your Honour, I would like to draw your attention to the fact that my client was never cautioned about his right to silence. Pursuant to Section 397 of the Police Powers and Responsibilities Act, and pursuant to Schedule 9, Regulation 26 of the Police Powers and Responsibilities Code, suspects have the right to remain silent and refuse to answer questions. The officers failed to advise my client about this, and it is evident my client is answering questions with gratuitous concurrence due to intimidation by the police officers. It is clear in the case of my client that the arresting police officers failed to caution my client properly and obtained some confessions and admissions improperly. Pursuant to Section 5 of the Police Powers and Responsibilities Act, one of the purposes of the Act is to ensure fairness to and protect the rights of the persons against whom the police officers are exercising their powers under this Act. However, statutory requirements of fairness were not afforded to my client. It is evident that throughout the interaction with my client, the police, and the support officer, gratuitous concurrence is occurring. This is further evidence to the fact that my client's admissions and confessions are involuntary. So, Your Honour, in light of all of this, I request you exercise your discretion under Bunning and Cross and exclude the evidence improperly obtained against my client.